and it's clear. Strict compliance with statutory provisions governing service of process is required in order to obtain jurisdiction over a party. It's clear that that didn't happen. Well-established law determined that an order entered without subject matter jurisdiction is void. You definitely didn't have subject matter jurisdiction because you never pled, or at least in the record, there's no evidence that jurisdiction was ever pled, despite what Ms. McCarthy just said. But I'm going to hold her to that. And you can go to Cole versus State, that's 714 SO2D 479, 489-490. That's out of the second DCA in 1998, by the way. And the Florida DCA did hold that an order entered without subject matter jurisdiction, the second DCA did, is void. Now, we can go back to Rule 12.540 as well as 1.5404B, B4. That states.
Well, I was about to ask you, is that the rule that you're citing as the basis for this emergency motion that you filed?
It's the basis for everything, that the underlying order is void, and I can challenge jurisdiction at any time. And the fact that everyone has put in such an effort to disregard the question of jurisdiction, we want to say is res judicata, and the second DCA never addressed subject matter jurisdiction.
Sir, I made a finding on the merits in that previous order, and then also made a comment about res judicata. But go on.
Yeah, and you're wrong. It wasn't merit. If it was litigated, show me exactly where it was litigated. That's not difficult, and you're supposed to be a hearing officer. You've injected yourself in quite a few of these hearings. If you have a witness, Mr. Denton, which I didn't know you were the attorney, have the witness come forward and produce the document so that I can cross-examine the witness as to the veracity of the document. There's
a previous finding by Judge Ayers regarding res judicata. There's a previous finding on your.
No, she did not. Judge Ayers cited the case that did not apply to this case. She never addressed the 120-day service of process, and if she did, show it to me.
And Judge DePaul made a comment that res judicata appears to apply on the.
Appears. Tell him to prove it. That's Judge Smith. Tell him to prove it.
It's a she. Judge DePaul handled the emergency hearing, or
she may have she recited what Miss McCarthy said. I don't even know if they're listening or not. Whether she said it appears.
Next parte order that determined your motion was not an emergency.
No, that's fine. But the bottom line still exists. There's no evidence that you served within 120 days. Just have one of the judges say that the 120-day rule for service of process does not apply to Mr. Doss or people who are similarly situated to Mr. Doss. That question has never been addressed. Tell the judge before they rubber stamp it, because we know that Gregory versus Rice stated that a judge should take he can take your recommendation, but he's not merely to rubber stamp it. He's supposed to go and check the record. So it should be really easy for them to just write the doggone order out. And then I can either mandamus or whatever we have to do. Because now that becomes a fundamental law, an issue of fundamental rights protection.